and I believe, and I wasn't in there, there was Ms. Hanson, Dr. House, and Dr. Meyer. And with a request for reconsideration, the committee votes strictly up or down, whether it has merit or not. And then if they say it has some merit, then it goes to the full board. So here we are at the full board now to discuss the request for reconsideration of Dr. Kenneth Starling. And I was not in there, so we rely upon the people who were in there to discuss it.
Reconsideration of what?
From a, well, it was from a consent decree that was signed in 2010.
2010.
Right. Which is
from 9.
2009, I think there was an informal hearing, an informal meeting, and then in 2010, March 2010, I think the consent decree was signed.
Is that what it is?
I think that's correct. And the consent decree that he wants to be changed, I think fined him $20,000 and took away his right to prescribe narcotics and other dangerous drugs.
So,
But he's got his drug license back.
Oh, he does have his drug license?
So he's in no restrictions at this point.
So he wants his fine money back.
Doctor, you can talk at any time,
Okay.
by the way, but I'm summarizing what I think you said, is that he has his dental license, he has his drug license, he's working every day, he just wants his record expunged. There's no restrictions on him that we have. Is that correct?
That is correct. And the reason,
And he'd like a refund on his fine.
the reason that I'm asking for that is, I'm sorry, that the materials that were found by Kent Morrison back then, if I may sit and read something to you guys, is that okay? And I hope this will explain a little bit about why I think that I'm entitled and I think what you would do in your own positions if it were you. My name is Dr. Kenneth Starling, and I have been practicing since May of 1997. I'm here today so that you may evaluate the evidence that I have that shows I could not possibly have been guilty of transgressions outlined in a consent decree dated March 5th, 2010. I was charged with, and under duress, signed a consent decree and was fined $20,800 for writing prescriptions while I was under suspension and while I had no DEA license. This was secondary to a DWI consent decree and voluntary surrender of my DEA license and mandatory 90-day drug rehabilitation at Palmetto. I don't contest that consent decree at all. I own it, I went, I did my time. While I was there, I surrendered my DEA license and number in November, secondary to that consent decree, which you may and should have a copy of in your package. I sent that to Rachel. I do not contest that one. While I was away in alcohol rehab at Palmetto Recovery Center in Rayville, I was called away by the board to be present for a dentist-to-dentist discussion. I'm sure you've heard that term. When I came before that oversight committee, the board investigator at the time, Kent Morrison, overseen by Director Ogden and Attorney Begay, had already typed up a consent decree. Kent Morrison told me he had a hunch and took it upon himself to search the Louisiana Board of Pharmacy's PMP website. There was no complaint nor investigation underway. The erroneous information, which I will read to you, resulted in a consent decree already having been typed up. A $20,000 fine was waiting for me and levied, and unless I signed the damn thing, per Dr. Blackwood, my license would be revoked. Of course I signed the damn thing. Each of you, under the duress I was subjected to, would have done the same thing. You members may have never been subjected to the terror of losing your license and tens of thousands in fines for something you never did wrong. Can you imagine how that felt? Given no alternative to signing what was before you or losing what you worked many years to achieve. My license, as a result, has been scrutinized for 10 years unfairly by both insurance companies who will not credential me and the public who has looked on the LSPD website and seen my name as being a punished dentist. Kent Morrison had no DEA number, therefore, he either had to get into the system or likely borrow someone else's DEA number. Now, pursuant to the Practice Act, I looked it up, Chapter 37, Section 760 says the board shall investigate complaints of illegal practice or violation when evidence is presented to the board. Again, at that time, there was no evidence presented, there was no investigation, and Camp had no reason to access the DEA's website. I have met with Rob Chadwick with the State Inspector General's Office, Pat Inglabe with the Private Investigators Board. I have corresponded with both Senators Mills and Peacock. They all have asserted that the board's action at that time were not only illegal, but outside the scope of the board's mission of protecting the public. This is a direct quote from the Pharmacy Board pertaining to who can access private information. PMI, or prescription monitoring information, submitted to the board and audit trail information shall be protected health information, not subject to public or open records law, and not subject to disclosure. Prescription monitoring information and audit trail information shall not be available for civil subpoena from the board, nor shall such information be disclosed, discoverable, or compelled to be produced in any civil proceeding, nor shall such record be deemed advisable as evidence in any proceeding for any reason. That being noted, please don't get lost in the actions of Camp and other board members. There's another side of this. You will now hear how the items found in the search were simply just wrong. Ladies and gentlemen, I could not have been possibly guilty to begin with. That's right. You see, as a result of the previous consent decree, I surrendered my DEA license. Firstly, I could not write, nor would a pharmacy fill any controlled prescriptions. Second, I was physically detained in Rayville, Louisiana, which is in the middle of a cow pasture outside of Monroe. There is no way to get in touch with anybody up there. I was physically detained and had no access to patients nor the means to prescribe any drugs, controlled or not, written or phoned in. It's just not possible. Thirdly, the prescriptions written in my absence were done so by dentists that were filling in for me at my office caring for my patients while I was at Palmetto. Lastly, prescriptions to patients called into question at the time were mostly when my DEA license was intact and well within my rights to prescribe. I have submitted the charts, which you each should have, from each patient that were called into question by Camp Morrison. You will see that the patients in question, a list given me by Morrison, were seen by other doctors, and these doctors, not me, wrote the prescriptions. Each chart entry is annotated with the prescribing doctor and has their signature on it. Brian Begay and Barry Ogden could not serve then as judge, jury, and senator without bias. Fraudulent information was brought forth. The board attorneys and directors then have failed in their duty to address illegalities. Board directors and attorneys in the past have a fiduciary duty to correct the record in cases of fraud and criminal conduct, both occurring in this case from its inception. This moral and ethical duty has been sorely absent. So, not only was the original investigation unfounded, the results of it were used against me illegally and without the benefit of due process. The patient charts and letters submitted show that at no time did I treat the patients nor write them prescriptions as charged in the consent decree. I had no choice but to sign the consent decree and fork over $20,000, which I had to borrow from my mom or lose my license. Doctors Blackwood, Melanson, and Taylor made sure they would get their money by threatening my license to practice dentistry. If this sounds unreal, it's real. I was so terrified by being blindsided by these false allegations that I had no choice but to sign it. This was hardly a dentist-to-dentist informal meeting. I requested a reconsideration a few years ago, and at the time Dr. Blackwood wrote that my request did indeed have merit. The following meeting revealed that I hadn't requested the right thing at the right time, so the reconsideration wasn't officially heard, though I presented all the evidence. It is now my request to you that the entirety of the consent decree be reconsidered, reversed, expunged, and all monies paid by me be refunded in accordance with what is right, morally and ethically. I'm sure you would want the same if this wrongdoing were directed at any one of you. Thank you for hearing me, and I hope that this new board has heard the truth and will act accordingly and do the right thing. Each of your good nature deserves and demands it. Thank you.
So, we have a discussion based on the hearing today?
Right.
Well, in the summary, the board has three choices. One is to deny his request, and nothing happens, and he just continues with what he has in the past. The second is to, as somebody mentioned, is to throw out the consent decree and null and void it, and then you're back where you were before, which is in an investigation leading into a formal hearing. And so the DOC, the consent decree stopped the investigation in the DOC. So that if you throw out the consent decree, that you go right to the investigation in the DOC or the informant. And the third is to, as a compromise, is to send Brian into an investigatory phase and check all these charts and talk to the doctors who sign prescriptions, because he's claiming that these other doctors signed prescriptions illegally because they were signing prescription pads that didn't have their name on it. And just confirm these kind of things and then get back to us with a report. So those are our three choices. Is that correct?
Who was on the DOC?
House, Hanson, Meyer.
So, what did the inspector do? I mean, what did the inspector general find? I mean, it seems like if there was some wrongdoing, that they would have come back and.
Well, Camp Morrison, to me, rumor has it that he is losing his
Well,
license.
I'm not talking about rumor. I'm asking you what
That's
did
all I
the
can-
inspector general come back? Did he say specifics with your case?
Never got back to me specifically with my case. I just heard that Camp's going to jail for the illegalities.
Involving your case?
Mine and many others. I don't know the details of those, but the OIG did, I met with them in my house, and they said that they would take up the matter, look into it, that what happened sounded very illegal, just the finding of the information itself. But that aside is the information that they found. It is the meat of the consent decree, which is just not true.
Okay, so I guess where I'm going with this is the fact that the inspector general is aware of this and kind of potentially looked into it. Is that correct, Rusty? I mean, so if there was some, I'm asking.
I would question when he met with the inspector general, because we have a letter from the inspector general saying I met with a bunch of people, I didn't find any criminal wrongdoing. When did you meet with the inspector general?
This was years and years ago.
So
I mean, I guess what I'm asking too is that piggyback to, you know, I think that needs to be included. I mean, some of the investigative work has already been done, I guess is what I'm saying. But, no?
No,
You see what I'm saying? I mean,
one of the complaints that Dr. Starling had was that investigation was begun before he had his DOC. And so we were going to wait until we talked with him so that he would suspect, that we were some sort of conspiratorially investigating his case. We want to hear what he had to say. So now we would have to confirm the facts of what he's saying, whether it's true or not. But we want to investigate further. We don't know. We weren't there. We weren't off the board back in. So
no, I understand that. I'm just saying, shouldn't we as a board include the inspector general, get some information from the inspector general? Because what he's saying is that the board did him wrong.
I agree with Dr. LaSalle. What he's saying is that he has suffered an injustice at the hands of the board, which it was composed of different people that are sitting here. And if the allegations that he is making, if those allegations are correct, then it needs to be rectified. And I don't think the board should investigate itself. I think what we should do is turn the matter over to the Inspector General, let the Inspector General do an objective investigation. If the Inspector General finds that there's merit to what this doctor's saying and that he was treated unfairly, that needs to be fixed.
Thank you so much.
Well,
It's not articulating that well at all. Thank you so much.
my understanding is that he spoke to the inspector general some years ago, and Dr. LaSalle and I met with the inspector general last year, and who drafted a letter saying that that he's done an investigation, not specific to Dr. Starling, but he told us that he met with 30 members from around the state and many witnesses, and that he didn't find any criminal wrongdoing. So.
Was that for Dr. Starling's case, or
No,
that was just
It
cases
was
in general?
in general.
Right.
Well, I think,
But presumably, he must have been one of the ones to whom the
well,
inspector.
I don't know if that's the case.
Exactly.
I mean,
all could have got dropped, you never know.
Yeah, so I think, I don't know what the process and the procedure is to refer to the Inspector General, but it's my recommendation that we do that and have the Inspector General say, yes, well, I did look into Dr. Starling's case and found there was some merit to it, or, well, I did not look into that, and so we're asking him to look into it.
Well, the other option we had is just to throw out the consent decree and go to a formal hearing. And then he can present all of his evidence in a courtroom setting, either within the board or within the.
Yeah, but that doesn't address the allegations he's making. The allegations he's making are allegations against the board and the board's activity. So those allegations need to be looked at by an objective, independent body, like the Inspector General.
Well, he has the option of doing an administrative judge.
But
Or,
that-
yeah, or you could do
But
that.
that's gonna cost him money, and it's gonna cost us money, if the Inspector General has already looked into it.
And it would be very difficult to go to another formal, given the time that has passed. We don't have records from the investigation from back then. We only keep those records for 3 years.
But
We do keep the consent decrees forever, but the investigation part we don't.
just to review, there was a couple of things that I had, I mean, not that I don't think he has some justification for this, he does, but there was a couple of things that I thought were questionable. One is he questioned the fact that we investigated him before we had a DOC. I don't have a problem with that. We do that quite often, I think. We look into matters. It's like if you have someone with a drug problem, there's no problem looking at his pharmacy record before he shows up, because it seems like a waste of time to show up and say, oh, we don't know anything about you. I mean, y'all tell me if that's right or wrong, but we investigate people knowing they're coming in to talk about it. And the second thing is, he made an accusation that the board has no right, through its employees or investigators, to look at his drug history, but we do. He mentioned things about civil cases, which is, if somebody's suing you, that's a different thing, but we're not civil. We're administrative and we're the state. So we can look at your drug license. I can look at your drug history tonight on my computer, by the way. It's just something, if I'm doing it maliciously, then I'd be in trouble, but I
I
can
could
look
have
at.
quoted something that's irrelevant and strike that. The point
So
was.
the point of it is, I mean, those two contentions, that we don't have the right to investigate you before we talk to you, and that we don't have the right to look at your drug history, then
I'll give you that.
I would throw that out, because Camp Morrison did, through the state board, has the right to tell us what your drug history was.
Okay, well,
what prescriptions you're
I'll
on.
strike that then and just go with the meat that
Is that
the
agreed?
consent
I mean-
decree is wrong.
You don't think we have the right to know what prescriptions are written by someone who's accused of writing prescriptions illegally?
And I think the meat of his complaint is that he entered into a consent decree admitting that he wrote prescriptions for controlled substances when it wasn't him who did it, and he was in a drug rehab
Couldn't possibly have written them.
institution at that time. So I think that's what we need to verify.
Well, I have no problem with that. And the other thing I asked him, by the way, is, all those people he mentioned are gone for 3.5 years or more, and he's waited a bit along as far as statute of limitations or whatever. As Rusty said, is that as things go on in life, evidence gets destroyed and people are gone,
And I would like you gentlemen
and
and
harder
ladies
to justify anything.
to know that the reason that I have waited so long to come again is because I knew that those monsters that used to be in the board are no longer there. And I heard there was some righteous, fair, right, good people on the board now. And I figured if you guys wouldn't do the right thing, I have absolutely no shot, because the other board certainly wasn't going to.
What we're left with is, that we have this evidence from 2010, you can go back and look at it.
Well, the evidence I have is all of my charts. I have all of the patient's charts still. I have all of the prescribing physicians. I have notes from pharmacies admitting their wrongdoing. I have all the evidence that shows I didn't do what the consent decree in Camp Morrison said.
Right.
I have all that.
So, I mean, maybe the results of the investigation aren't inconclusive, but there's not enough evidence there to form an opinion one way or the other of what happens.
I would just like somebody other than the board to issue that opinion, because
Right.
we
Great.
look like the.
Can't investigate ourselves.
the executioner when we are conducting this investigation of ourselves. So
Exactly.
that's, and I'm perfectly happy if that's the conclusion it comes to, but I just think that somebody else ought to be presenting us with that conclusion
I
so
agree.
that.
I would gladly comply with that. I think that's a wonderful alternative option.
So Rusty, would it then go back to another DOC or
Well,
go to?
Well, we look, it sounds like what y'all want to do is send it to, ask the Inspector General to look at this. And if the Inspector General looks at it and finds nothing, then nothing is done. If the Inspector General looks at it and finds some wrongdoing, then we would come back to the reconsideration committee and start over, see whatever we can do to fix it. Right.
I would suggest, Dr. Starling, for you to make your points very clear and concise so that we can present it to the Inspector General.
Okay.
I mean, don't think that way it's not, I mean, make it very concise.
Shall I write that up to you and present it, email something
Well,
to you?
I think what we could do is call the Inspector General and say, look, here's the situation. We would like if y'all would please look into it for us. We don't want it, it's hard for us to investigate ourselves and see what they want from us and what they want from him. I think would probably be the way to do it.
Right. They'll determine
What they
the
need,
course of the
yeah.
inspection, the investigation, how they're gonna, what information they'll need from you, what information they'll need from us, who they're gonna interview, and then we'll, see what they say.
Right, we don't have a lot of information in
Why
2010.
come here, you go after the guys that apparently have done it?
Well,
Yeah,
one
we
thing
can't
is,
investigate Browning Begay and Camp Morrison, they're not our employees anymore.
one thing is because it's on your record,
And HO, yeah.
it does affect your ability to work with some insurance companies. Is that right?
Absolutely.
Yeah.
Can't get
It's
credentials.
a big deal.
So I had the other question is, we've notified the National Practitioners Data Bank. We can't take that back.
I think we can amend.
Well, we can,
That's what I was asking.
Look, the consent decree that is there is always going to be there. We can never destroy it. We could have an amended consent decree, which amends and says whatever we want to say, where, hey, we find that, what happened back in 2010 wasn't right, or something like that.
So if an insurance company looks him up after this is done and it goes your way, which is fine, then they're gonna see the new consent decree and the old consent
Right,
decree.
right.
But they're still gonna be there.
They'll still be there, that's right.
But
I
we
can al-
can do the
With National
National,
Grid,
we can do
amended
amended where it takes all
report.
away.
And
There
it
is
is-
still a record of it, but it'll show that it's.
As I have to do now to get credentialed with insurance, I have to explain this whole ordeal. I could write that there's been a second consent decree, it's been reconsidered, I've been found not guilty, rescinded, whatever
I just want to know.
the jargon needs to
I
be.
don't think we've ever done that.
No, I mean, no.
A do-over.
Right.
Over the past.
Right.
I have a question to the thing that you said. Are you saying that when you were in the rehab center, there were no phones in the rehab center?
Phones to call cabin to cabin, but you couldn't call out without express permission. And if I were to want to call in a prescription to somebody, I would have to know their name and pharmacy number, and that's just not available
You
in.
have to leave the facility, is what you're saying.
Yeah, and I never did that. I mean, it's not a lockdown, but it's a cabin system in the woods, and there ain't no, I mean, there's carrier pigeons, and that's it.
And following this, you haven't had any incidents before.
That is correct. A few complaints that have been nullified, but no, all good.
And the other question I asked Rusty before, and just maybe a quick discussion, is it legal for us to write a check to a dentist? We don't know the answer.
We don't know the
We can get a
answer.
refund or not. We're not sure it's legal for us to write you a refund check.
Well, with all due respect, I wrote y'all one.
Well, we're talking about state law, we're not talking about what you feel. It has to be researched.
We'd have to have
Yeah.
Mr. Grove research that, because
Could you just, another way to do it would be just to, maybe
we don't know if
send
there's
to
any way to do it.
the,
Yeah, we'll cross that bridge when we get to it.
Yeah,
It's-
right.
Yeah, you have to resolve some
Absolutely.
obligations.
Well, I'm just bringing it up in case it goes that direction in his favor. It's like, we gotta figure out if it's legal for us to write him a $20,000 check. I know we can't do a refund on a license. It's not legal.
We'll look into that.
We'd have to, it's an interesting question.
I wouldn't tell anybody.
We're not that kind of board anymore.
I'm really so glad to hear good suggestions and open-minded suggestions, and even the thought that this may be reconsidered, because last time, as I said, it was just monsters, just big, bad, evil monsters who were out for money, 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 and nobody's rights. Protecting the public, forget about it. That went out the window. That was then. So I really appreciate y'all hearing me.
I'd just like to say, for the record, I'm sorry that you feel that way, but I really take offense that you're calling these people monsters. We all give our time to serve on this board, and those same people, I feel like did some very good things, so I don't want anyone thinking that they were all monsters being.
I apologize,
concerning
not
the
all,
state.
notwithstanding the good ones, the ones that I had to deal with that did this to me were very monster-like in their attitudes and actions, in that they would not grant me the right to say, excuse me, I'm not guilty. They acted like monsters. Excuse me if you felt lumped into that. I did not mean you or any
I feel
person.
the same way. My question, just one last time we talk. You talking about money, money, money. Do you think these guys were getting any money? Or you think, why do you say money? Because it didn't matter to me. If you get a fine or don't get a fine, I'll go home tonight and have dinner. It doesn't matter to me.
I understand that.
I'm here to protect the public.
I understand
If you pay
it.
a fine, don't pay a fine, I don't get anything. You think they got something?
If,
So why would
no,
money be an issue for them?
Because it was $20,000.
it's $20,000.
No, I mean, why would you think it would be an issue for the state board members at the time? You say money,
I'm
money,
not,
money, why would they
I didn't
care?
ever say that that the members got any of it. That's never been a contention, that y'all were paid anything. No. I think I know that.
No, you just said money, money, money was their only concern.
To get my money back, sure.
No, I thought you were talking about the state board members, they were only talking about money. Okay, and you misunderstood.
No, not the members themselves, no,
Okay,
no.
So in summary, is he the one to file with the Inspector General's office? Because it's his move?
Well, I think that I could probably call the Inspector General's office and say, look, the board would like, if y'all would, for y'all to look into this, because we've got this complaint and we're concerned about what happened in the past. We don't have the resources to research, to investigate former employees, but there are these allegations, and we take them seriously, and we would like, Inspector General, if y'all would investigate. That's, I think, what I could do.
Or see if they already...
I would suggest, Rusty, you know, I'm a big person on the written word, I think it needs to be in writing.
Well, certainly, I think I'd call him first.
Because I don't want this gentleman here to, you know, to say.
I think I'd call first.
You know, I want to make sure that we do it, and then there's some follow-up. That you know, I don't want Dr. Starling to say, yeah, you did it, and then, you follow what I'm saying? I mean, I want you to write to him with his summary, with his points, and then I'd like you to follow up on it in a couple of weeks, and then if you don't get a response, then let Dr. Smith know.
Well, I think
Go
the way to do it would be to call first and then write. I
Yeah,
do
yeah,
think
that's
I need
fine.
to write, but I think I wouldn't want him to get the letter cold.
Right,
from there. Right. No, I agree. I just wanted him to know that it's going to be written.
Sure.
I mean, we can only do so much, Dr. Starling. I mean, if the Inspector General does not, you know, respond.
Right.
And says, look, we don't even have any records, then we're back in the same position.
Yes, ma'am.
So I'll call him and I'll write him a letter and include the information that Dr. Starling has provided to us, and assuming that they're open to me sending that, and ask them if they'd be willing to investigate.
So am I correct in assuming I need to write a very concise report of, I was charged with this is how I could not do it, I was charged with this?
Well, why don't you do that? It might help. Otherwise, I'm just going to send what you've given us so far.
Okay.
But if you feel like a concise report would help, and
I've already got everything. So.
Yeah, well, it's up to you. It's up to you. I'll send it over to you.
Thanks for coming by.
Thank y'all for hearing. Thank you for hearing me. Appreciate it, really. I know y'all do hard work, and I do appreciate y'all. Thank you, really. It's just the bad ones can be really sticking in your head. That's the ones you remember, right? Thank y'all here very much.
Right there.
Thank you. Thank you.
All right.
So now we're going to go into...
Now we go into executive session.